All rise. The Honorable, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you so much. Good morning. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Bill, and I'll be presiding. To my right is Judge Hunter Murphy. To my left is Judge Fred Gore. Roderick McFarland is serving as our clerk today, and we thank Tom Salou for being here too. We have one case on the calendar. It is State versus Johnson. And if the appellant is ready, you may proceed, and just let me know if you want to reserve any time.
May it please the court. I am Karen Strickland, and I represent Zachary Johnson. I would like to
Ms.
reserve...
Strickland, could I get you to move the mic just a little bit closer
Closer
to
to
you?
me?
It kind of bends a little bit too, if that may help. Just,
Yes. Is that
yeah,
better?
much better. Thank you.
Okay. I would like to reserve 5 minutes for rebuttal. A fundamental purpose of sentencing is that the trial court must take into account factors that may diminish the offender's culpability. To this end, the Structured Sentencing Act provides that a trial court shall consider mitigating factors, including whether the defendant acted under strong provocation or the relationship with the victim was otherwise extenuating. These statutory requirements were not followed in this case. Mr. Johnson...
Let me just ask a clarifying question. Now,
Yes.
the statutory factors are only going to apply to the felony sentence, correct?
Yes, that is my understanding.
And with that, I know there's a lot of talk about kind of what happens later, especially like the shooting of the vehicle tire and things like that. Do those matter for our consideration of the mitigating factor, or are we only looking for how the mitigating factor applies to the criminal conduct related to the felony? Which in this case, the only felony he was convicted of was the discharge of a firearm into an occupied dwelling, correct?
Correct. I do think that the trial court has discretion to consider the totality of the circumstances, and I think it's important to clarify what we are arguing and what we are not arguing with regard to the mitigating factors. So this is a sentence in the presumptive range. So we are not arguing that the trial court was required to make written findings of fact. We are not arguing that the trial court was required to sentence my client in the mitigated range because there was evidence of mitigating factors. What we are arguing is really focused on subsection A of the sentencing statute that says that the trial court shall consider these mitigating factors. And while I do think in doing so, the trial court has broad discretion to consider the circumstances and to potentially reject those mitigating factors, which would be reviewable only for an abuse of discretion, our position is that the error that was committed here was essentially procedural in nature, that the trial court was required to at least consider these mitigating factors, and that there's just simply no indication whatsoever in the sentencing transcript that the victim's behavior or the victim's culpability was considered at all, even though you have this situation where she's rampantly abusing crack cocaine and alcohol while she's pregnant with Mr. Johnson's unborn son.
Let me make sure I understand. So
Yes.
you're saying, I mean, I see what you're saying. The evidence has to conclusively establish the mitigating circumstance. So make it easy. Let's say your defendant was discharged and honorably discharged, and that's a mitigating factor. And that's subjectively, you can see that. And there's evidence, plenty of evidence he was honorably discharged, but the attorney never asked the court, hey, I want you to consider the fact that he was honorably discharged. But it was all before the court. It's conclusively established. Is there a preservation issue? Is there not a preservation issue? But assume if it was preserved, assume it was preserved, you're saying one, the court needs to at least consider it since it was conclusively established. And are you saying it's preserved anyway, even if the attorney didn't ask for it?
Yes, that is exactly what we're saying. And the reason why we're saying that is because this is a statutory mandate that the trial court shall consider these factors. Even if the trial court ultimately sentences in the presumptive range and the trial court doesn't make formal written findings
So
as
you need to, now you need to convince us that the evidence conclusively established one or both of these mitigating factors, I think. I mean, I think I got, unless I'm missing something else, I think I got everything you're saying so far. So so I think the crux of your argument is that you think that you're saying that evidence conclusively established both of these mitigating factors, at least one. Is that correct?
Yes, that is our position, is that even though defense counsel didn't specifically make an argument as to these mitigating factors, the trial court should have considered them because the state really, what you have is a defendant, Mr. Johnson, who actually testified at trial and essentially accepted responsibility for this offense and explained to the jury why he did this. He candidly acknowledged, he even says in his testimony, I know I did wrong. I know that but he was very provoked by the behavior of the victim, which really, this is not just a relationship gone bad or a breakup issue or fighting about infidelity. This is a far more serious situation where she is potentially physically harming the couple's unborn child. And I think that, I'm sorry.
Two questions.
Yes.
I definitely agree with you on the potential harm with the child and where the relationship was, but kind of two branches. First, is the mother of the child actually the victim for the purpose of the second part of this mitigating factor? Or are we talking about the homeowner or the other person in the dwelling? And then also, what do we do with the fact the jury rejected his testimony that he thought the house, that she wasn't there, nobody was in the home?
Right, yeah, I understand your question. I mean, I think that with regard to the second part of your question, there is somewhat of a tension between the jury's verdict. I mean, I think that the jury clearly found that he did not try to enter this home with the intent to kill anybody. And I think that that is highly significant. At the same time, as Your Honor points out, the jury did find that he at least had reason to believe that the dwelling was occupied. And that's how the jury was instructed, was that they either had to find that he did believe or that he had reason to believe. So I think that the jury, at a minimum, could have found that he sincerely but unreasonably, irrationally believed that nobody was in the home because nobody answered the door when he was knocking and that, you know, he couldn't hear. Or alternatively, that even if he did believe someone was in the home, you know, what he did with essentially birdshot that he's explaining. I mean, again, this is not rational behavior. This is clearly criminal behavior, and we're acknowledging that. But facts like he's not using the largest shotgun shells or the slugs that you can. He's using birdshot that is typically used for hunting squirrels and birds and small game. Factors like that, I think, led the jury to reject the idea that he went there and just shot off rounds with the idea that he wanted to harm these people in the home. And I do think that that is significant and would need to be considered with regard to these mitigating factors. I think that with regard to the first part of your question about who is really the victim here, I mean, potentially I think they are both victims, but he still acted under strong provocation, and his relationship was extenuating with the victim, with the girlfriend. And so I don't think that the fact that there was another person in the home necessarily takes away from the inquiry, which is there some sort of circumstance that morally shifts the burden, the responsibility for the crime onto the victim?
We have to, but is your burden on appeal to show that it conclusively established that? I mean, and I'm not saying there's conflicting evidence on that point or not, but if there is, what are we, if there was, let's say there's conflicting evidence whether your defendant was honorably discharged or not. There's conflicting evidence, and nobody asked for it. I guess we don't do anything because it wasn't conclusively established. So I mean, it's your burden to show us it was conclusively established. Otherwise, it was a presumptive sentence, and we don't do anything. So, is that correct? I'm just making sure I understand.
I do think that that's correct, and.
Under the current state of the law, that's.
Yeah, under the current state of the law, and we did provide in our memorandum, this goes back to the preservation issue, but the memorandum of additional authorities, a couple of cases, Gardner from the Supreme Court, and then I'm going to mispronounce it, I'm sure, but Minardi from this court that discusses the duty for the trial court to find a mitigating factor when it is uncontroverted and manifestly credible, even when the defendant does not.
So there was
request it.
evidence that he thought that people were in the house, and there was evidence that he didn't think that, based on did she yell back at him or whatever. But I guess you're saying that it doesn't really matter because in either case, it was clear that he was acting out of some kind of provocation, just out of anger, rage, or whatever you want to call it, because he thought that the mother of his child was or had been at this place where he thought she was engaging in drug activity or something, I guess. And so that doesn't matter, I guess, is what you're saying, because there's a conflict in evidence.
That is correct, Your Honor. That conflict in the evidence, I believe, does not matter, particularly in light of the fact that the jury found no intent to kill. I mean, I think that maybe this would be a different case if the jury had found intent to kill and that maybe there was some other motivation. But I think that the trial court has to respect the fact that because they did not find intent to kill, I think that really supports the idea that this was an irrational act of rage aimed at the fact that how furious he was that not only was she engaged in this behavior, but she was completely callous about it when he confronted her about it.
I guess, counsel, in that line of thinking, isn't that more for the jury to use all of that evidence or conflict of said evidence in their evaluation of the provocation for the underlying decision of guilt versus it being a mandate or force on the judge to use in mitigation? When in the way you're arching your argument thus far, I'm seeing heavy lean to this is provocation, this undermines the intent, versus it being something that would mandate the court to have to use the conflict of said evidence and something about mitigation.
Right, yes. If I understand your question, I mean, I think it's both. I mean, I think that you have the elements of these offenses, but even if you just take the felony that he was convicted of, discharging a weapon into an occupied dwelling, it's a very different situation if you have some cold-hearted boyfriend going to the home and I just want to discharge rounds into somebody's home, and there's just absolutely no justification for it. I think
not disagreeing with that, description, but that goes into the underlying evaluation of guilt and the culpability levels of said guilt. Get us to, or at least get me to where this forces the requirement for because it exists there. I guess my analogy would be someone's convicted of a DWI driving, a Honda Civic versus a Ford F-350. Do you cut them slack just because they drove a small car, but there's still levels of guilt? So I'm looking at cutting the line after said culpability argument to getting to what you're wanting us to evaluate for the mandate for the mitigation.
Yes, yes. So I think with the example that you gave, the type of car that a defendant was driving when they commit a DWI, while it may affect the damage that was done, it doesn't really reflect on the defendant's culpability.
Well, shotgun shells couldn't either because he could be so enraged, because I'm going back to your argument now, using your words just like you broke down my analogy. He could have been so enraged, he didn't take the time to check to see whether he had double buckshot in there versus birdshot. So it cuts both ways. He still pulled the trigger regardless of whether, but the jury still made their decision. So I'm giving you the benefit of the doubt, using an analogy, might be a little off, but still get us to the mandate for the mitigation, how that spills to the mitigation piece.
Yes, I mean, I do think, I understand what you're saying, that there is some overlap between, say, the element of intent to kill and what the mitigating factors are. But the legislature still mandated that the trial court shall consider these mitigating factors. And the fact that this isn't just a circumstance that he is asking the court to consider because he believes it's compelling, it is actually a statutorily mandated mitigating factor. I still think the court has to consider that with regard to the felony that he was convicted of, even if the jury may have cut him slack on another one of the felonies. I still think that it is a separate offense and the statutory requirement still exists. And there are other circumstances related to this mitigating factor that really just go beyond whether he had intent to kill. I mean, you have this whole backstory of really he repeatedly confronted his girlfriend about it. He would actually catch her in the act of being high on crack cocaine while she was 4 or 5 months pregnant with his son. That's at page 332 of the transcript. She was drinking every day. She was smoking cigarettes. And when he confronted her about this, she said it was fine because she had done it with her past 2 kids and she knew what she was doing. This was at page 328. And going back to the fact of this being uncontroverted, I would point out that if this were not true, if his testimony were not true, the state could have put on witnesses to try to refute this. The state could have called anybody to say, well, no, actually she wasn't really doing this and she didn't say this. I mean, I think when you look at other cases from this court, like Mixian, for example, discussing the extenuating relationship and strong provocation, the court, there was strong provocation, but there was not an extenuating relationship in that case, partly because there was a lot of conflicting evidence about who was really at fault for the antagonistic relationship. The couple, this was another marital difficulty situation, but the son testified that really both parents were at fault. There was a therapist who testified that the defendant had harassed and threatened the wife, and so the evidence truly was conflicting. Here, it's very different because you have the state's own witnesses saying, yeah, he believed that she was doing crack cocaine while pregnant. That's why he went over there. She empathized with him because that's a terrible thing to do. The prosecutor made similar statements, like it sounds like she's a terrible person. She's doing drugs and alcohol while she's pregnant. You have all these statements made, and there's really no attempt to refute this circumstance. And when you consider both strong provocation and extenuating relationship, what the core of those things mean, this court has said that those factors apply when there are circumstances that, quote, morally shifted part of the fault for a crime from the criminal to the victim.
He wasn't charged with attempted murder. Did that issue come up on the burglary charge? I'm trying to remember.
I don't believe he was charged with attempted murder.
So how did the jury not find that he didn't try to kill her?
It was burglary with assault with deadly weapons intent to kill.
With intent to kill. Okay, so
Was the
let's say
felony
he
for
was
burglary.
convicted of that. Let's just say he was convicted of that. Would you still be here arguing the same thing, that these mitigating factors still apply because the reason he did that was because he was provoked into these and had this extenuating relationship?
I think that would be a harder case. I think that maybe, I think that the reason why that would be a harder case and it is the fact that when the court looks at these circumstances that morally shift part of the fault of the crime, the court's really looking at, well, is this offense less serious? And when you have circumstances, like in some of these prior cases where, I think it's Simonovich, the defendant he argued he was provoked by his wife basically taunting him about cheating on him with other men, and he reaches over and he strangles her and he kills her. And basically what the court said is the fact that she did that does not lessen the seriousness of the crime that was committed. So I think if he had gone over there with intent to kill the people in the home, we would be closer to a situation like that. I still think that there might be, I still think there would be an argument for extenuating relationship, for example, just because even if he overreacted to that extreme, it doesn't change the fact that those extenuating circumstances are there, which are far more serious than infidelity. But I will also concede that's a more difficult case. And I think that what the jury did find is highly significant here.
Let me ask this, because it kind of synthesizes where I think Chief Judge Dillon is and where Judge Gore may be a little bit, is the jury's determination that the state did not meet their burden of proof to prove beyond a reasonable doubt that he acted with the mens rea necessary for the burglary. Doesn't that still leave that it's not uncontradicted evidence of what his intent and what his actions were? The state just didn't meet their burden to show that intent, but it doesn't negate that there's a mix of evidence. So for uncontroverted, I would agree, like taking it in the light most favorable to the defendant, you're probably there. But given that you have to show uncontroverted evidence, and doesn't that mean that there's not different ways to look at it?
I still think the evidence is uncontroverted, and I think that what you're getting at is how would the trial court weigh this evidence, which is more of like a substantive
I'm more
issue.
in, for purposes of us saying the trial court did something wrong here, we have to say it was uncontroverted evidence of this mitigating factor.
It was conclusively established. And
Right. Well,
So for our purposes of our standard review for appellate review, we're not supposed to be taking into account that weighing of if the trial court would have given it or not given it, that kind of thing. It's, was it established, and is that the end of it? Or if the trial court could have gone either way on if it was established in the first place, doesn't that end our job here?
Well, I think I do want to take a step back for a minute for the premise of your question, because what that would require is for the trial court to consider conduct or alleged conduct that actually resulted in an acquittal. And I think that would be troubling to essentially allow a trial court to say, well, there was no finding. The jury, in fact, looked at this evidence and acquitted the defendant of this conduct, but I'm going to consider it anyway. I mean, I do think that when the court is considering mitigating factors, I think that would be a very troubling result.
Well, the thing, I guess my concern is, if I hear you, I think you're saying if he had the intent to kill when he went over there, then he would not be entitled to these instructions. The jury merely found that the state didn't prove that beyond a reasonable doubt, but that's not a finding that it conclusively established that he didn't have the intent to kill when he went over there. And if there was evidence he had the intent to kill, it just the state didn't prove beyond a reasonable doubt, but the evidence is there, then how can you say that that the defendant, it's been conclusively established that there wasn't the intent to kill when he went over there?
Right. Well, just to be, I apologize. I didn't mean to
No,
interrupt.
you're fine. Go ahead.
Just to be clear, we're not conceding that these mitigating factors would not apply. I think what we're saying is it's a harder case, but obviously it's not.
That's why I asked that question.
Right. It's not the case that is in front of us. And I think that when we're talking about whether it's uncontradicted, I mean, I guess they're really, there really isn't a lot of evidence on the other side. I mean, I think at most, the evidence establishes that where there is a conflict, it's on whether he might have known that people were in the home or not, but I don't think that's the same as having intent to kill, particularly in light of the fact that he's testifying, and there's no evidence to the contrary, that he's using a type of shot that it essentially is like, it's not, again, it's not the type of like slug that somebody would bring to a house if it's like, oh, I want to kill this person. The fact that he is using bird shot that he says is for small game and birds and things like that, I think is highly significant. So I guess I would push back on the any kind of argument that there actually is a real conflict in the evidence on whether he had intent to kill, because I really don't, I don't believe that that evidence exists. I really don't. And so I think that the issue at the end of the day is that the trial court does have discretion to weigh when it it's not bound by these mitigating factors. The trial court does have discretion to weigh these factors with other circumstances involved in the offense that maybe the trial court thinks are egregious or go the other way. But the point is that we are making is that that procedural interplay did not happen in this case.
And you're eating into your time, I just want you to be aware of that.
Oh, yes. Well, and I do want to just, I'll save the rest of my time for rebuttal, but I do just want to talk a little bit about Freeman and how it contrasts with this case or provides guidance on this case. And that is because what this court said was that the court did consider, the defense counsel specifically argued for mitigating factors. The trial court did consider those factors, and I actually pulled the sentencing transcript from that case. And what defense counsel says is, I'd ask you to consider several mitigating factors in fashioning your judgment. The counsel makes argument about what those mitigating factors are, and then the trial court says the defense can offer mitigating factors respectfully, but there's nowhere the court has to accept the mitigating factors. I've heard the mitigating factors, but I don't think the mitigating factors outweigh what the right thing is to do on this matter. That was what the trial court said, and so that's really all that we're asking for, is that this has to be considered. So I'll save the rest of my time
Thank you
for
so much,
rebuttal.
Megan. Thank you. We hear from State.
Thank you. Good morning, Your Honors. My name is Danielle Allen. I'm here representing the state today. May it please the court. I have 3 points I would like to cover today. First, that the trial court did not err in failing to consider the mitigating circumstance of strong provocation. Second, that the trial court did not err in failing to consider the mitigating factor of an extenuating relationship. And third and lastly, that the trial court, trial counsel was not ineffective for his failure to specifically urge these mitigating factors of strong provocation and an extenuating relationship.
As we're getting into that, I just want to know and ask a question. Looking at record page 6, the indictment for the discharge weapon does name both Kenneth Gornwald and Melissa Hardis as the victims. Is that was also reflected in the jury instructions as the victims? Or was it generic in the jury instructions?
I'm not sure, Your Honor. I believe it may have been generic in the jury instructions. For my purposes, I have been viewing the victim as being the woman that was pregnant with the defendant's child at the time. I believe that's the victim that matters in this case because we're considering whether or not that victim provoked the defendant, whether or not they had an extenuating relationship.
Does it have to be the victim causing the provocation, or is the relationship the only one that relates to the victim?
I believe that the provoking circumstances need to involve the victim, yes, Your Honor. And particularly in this circumstance, I believe that the charge by the appellant and the defendant in this case is that the provocation came from the victim, the woman who was pregnant with his child at the time.
Just generally speaking about that mitigating factor, have we ever held, or has the Supreme Court ever held that it's victim-specific on the provocation? So I'm thinking if Chief Judge Dillon decides to start beating me up right here. And I'm really mad, and I punch this desk, and I break this desk. Well, I've injured the property of the state. State wasn't a victim, or state wasn't the one that caused me to potentially have sufficient provocation to punch the desk because I'm so angry I just got beat up. Would I not be entitled to that potential mitigating factor in that situation just because what got injured or what got hurt was not the property or the person of the victim?
I believe that that would not be a case for the factor of strong provocation. Our case law fleshes out that an extenuating relationship as well, but I believe strong provocation is more apt in that case. But I believe our case law fleshes out that it's the victim doing the provoking towards the defendant.
Has that just been a de facto situation, that's the cases where we've been looking at, so that's what we've been talking about in context? Because just looking at statutory construction, if we've interpreted this as basically being a two-part mitigating factor, the relationship with the victim only seems to come in on the second part of that after the comma, correct?
Sure.
And there's
yes,
nothing regarding the victim under the first part of E8, right?
I believe that's correct for how the statute is phrased. However, I believe the case law has shown that the way we've interpreted whether that mitigating factor should have been considered is whether the victim provoked the defendant in causing him to commit the crimes that he did.
Thank you.
Does the evidence conclusively establish that he thought that the mother of his child had been using drugs while pregnant with his child, and he thought that she was over there using drugs? Was this the location where he had thought she'd been using drugs in the past, and he went over there angry about it and shot up the place? Is that basically what happened?
I believe that is the facts that the defense put forward and that the prosecution put forward. I don't believe that there was any evidence put on the record at trial that the victim, the woman pregnant with his child at the time, was not abusing alcohol and drugs. I believe that that was somewhat taken as a given and it was not contested.
So why isn't that provocation? That he went over there thinking that she's over there, and he got all enraged by it, and she's at the place. So maybe, I don't know if it was owned by the other guy, but so that could have been some provocation too, was here's this guy giving the mother of my child drugs. I'm just saying if that's what was in his mind, and that's conclusively established, that's why he went over there. I'm not saying it justifies what he did by any means, but tell me why it's not conclusively established that that's provocation.
Sure, yes, Your Honor. So in looking at our case law, strong provocation really can be broken down into two pieces. This court and our Supreme Court has said that the threat or coercion or violence needs to be close in time or nearly immediate. That's the first factor. And then secondly,
She's in that home, or he thinks that she was in that home taking drugs, harming his baby. Why is that? It wasn't like, I knew you were over there 4 days ago, so I'm going to go show up the place. I thought you were there now. That's why he went over there, because he thought that his baby was being harmed. Why isn't that? So that seems to be close in time, unless you could argue, but when he got there, she wasn't. At least there's testimony that she wasn't there, but he was already enraged, and he didn't cool off. I'm just trying to, so I mean, why is close in time not apply here? If he thought his baby was being harmed at that moment.
I believe that, and you just mentioned this, Your Honor, that it's very pertinent to understand that defendant claims that he believed that the home was unoccupied throughout the duration of this sequence of events, until the point that he got in his truck and fled. When he was confronted by the neighbor, he claims that he believed there was no one in the home at the time, including the victim, the woman pregnant with his child, as well as the homeowner. So I think that's very pertinent in evaluating whether or not he was
The
provoked.
evidence that he never thought anybody was there, he did think anybody was there after he knocked on the, well, he banged on the door, so he probably thought that somebody might have been there. So I'm just saying, why isn't it conclusively established that he was upset because he thought somebody was home, and then when he came to realize there wasn't anybody home, he still didn't have adequate time to cool down, which is, I think, one of the things that gets rid of, he was still in that provoked stage. I'm just trying to say, why isn't that conclusively established? I mean, if that's the evidence, we've got to determine, does that conclusively establish provocation or not?
I believe it doesn't, Your Honor, and I believe that there are two parts that both have to be met to prove strong provocation. That close in time or nearly immediate piece is the first part, but the second part, and that's fleshed out by our case law, is that it needs to be directed towards the defendant. We don't have cases that support that the threat of physical harm or violence or the coercion can be close in time or immediate, but not directed towards the defendant. Those two pieces are there, and so that's what we don't have in this case. We don't have that the threat of violence or coercion was close in time or immediate, and we don't have that it was directed at the defendant. And so because those two pieces both have to exist in order for strong provocation to apply, the state would submit that it does not apply in this case, and the trial court did not err for failure to consider strong provocation.
Counsel, is there some basis, and I tried to read back, was the thought of this being an ongoing abuse of drugs or alcohol, because it was ongoing, is that why the state conceded that issue? Because this wasn't like a surprise, oh my gracious, this is the first time this has happened, let me rush over. Why did, get me to, or help me understand, is the ongoingness of her abuse an issue for the state in evaluating the close in time prong?
I believe it is something to be considered in whether the strong provocation would exist in this case, whether the threat of violence or coercion or whatever the case may be was close in time or nearly immediate. I believe that our case law shows that this kind of ongoing potential threat of harm that the defendant alleges would not meet the burden that the defendant was required to meet to prove by a preponderance of an evidence that he was strongly provoked.
Was it conclusively established that that the mother of his child was doing drugs at this location several times? That's why he went to that location, because he thought that's what happened, essentially.
I don't believe so, Your Honor. I believe in looking back at the record, it's important to distinguish that there were two different locations. There was the crack house, the alleged crack house, where defendant alleges that the victim was residing. That is where, if I recall correctly, the defendant knew the victim to be engaging in these activities of using drugs and alcohol.
But not in this location.
This was a separate location. The night of this incident, this was a separate home. It was not the crack house that the defendant alleges that the victim was residing in at the time. This was a separate location. However, defendant did testify that he went to that home that night believing that the victim was there abusing drugs and alcohol potentially.
And I'm just thinking, if my son has a bad gambling habit, and I know he goes to some location all the time, and I think he's there and I go there, and he's not there, but I shoot up the place because I'm provoked, I mean, really, I'm mad not just at my son, but for this place housing a gambling place. And so, I mean, they're all victims, but I mean, I'm kind of been provoked by all that. But you're saying this wasn't the crack house, and so.
That's correct, Your Honor. This location, the trailer that the defendant went to and shot up that night is not the crack house that he alleges that the victim lived in at the time.
But didn't the testimony reveal or show that he didn't do the shooting until he saw the open beer bottles, which were right at the microwave that he shot at?
I believe that may be consistent with the defendant's testimony. However, the testimony from the homeowner was conflicting in that regard. The defendant testified that at first when he approached the home, he went up onto the porch and he knocked on the door politely, waited for a response, peered in the window, potentially saw beer bottles, got agitated, and then began shooting, starting with the door handle and then moving on to the window and into the home. But again, the testimony is conflicting on that. The homeowner testified that it didn't quite go down that way. The homeowner testified that defendant came out swinging. He showed up. He was angry. Defendant agrees that he grabbed his gun when he was getting out of the car to approach the house in the first place. And the homeowner testified that the defendant began shooting nearly immediately, that he may have knocked and then immediately shot out the door handle, walked over to the window, started shooting, yelled, I know you're in there, I can see your purse, before shooting her purse sitting inside the home. So there is conflicting testimony on that.
But would you agree, it looks like State's Exhibits 38 and 39 indicate open Bud Light bottles sitting right next to the microwave that he shot?
Yes, the photos of the crime scene do show that there were beer bottles sitting open inside the home that were visible through the window that defendant shot. Yes, Your Honor.
It would seem like if he came over there in a cool state, that would cut against provocation, because it's like, if he came over there, then he's not overly concerned that she's in there doing anything bad, and he just got mad when he saw the empty beer bottles and shot in there. I mean, I would think provocation might be more justified if he, not justified what he did, but it would be more of a mitigating factor if he really came over there. But you're saying he testified that he came over there in a cool state, and he only got upset when he saw the beer bottles and but how is beer bottles justify that there's some immediate threat to anybody, I guess? I'm just trying to think.
The state agrees, Your Honor. Yeah, I believe that the defendant's exact testimony was that he became agitated as he began to believe, in his words, that no one was in the home and that he had not, in fact, found the victim, the woman who was pregnant
It's
with
like the
his child.
state's evidence helps him, and his evidence helps the state. It's just kind of, at least one way I'm looking at it. I'm just trying to understand that. So he didn't get agitated until he looked in the window and saw empty beer bottles.
Yes, Your Honor.
And did not believe anybody was there.
That was his testimony.
That was his testimony. So that would be, if that's his testimony, I mean, I don't know how, I'm just trying to understand how and I would ask the defense that, how would that be justify a provocation instruction? Because, I mean, if you don't think anybody's there, I don't know, and that's when you became mad. I'm trying to follow that, but, okay.
Sure, Your Honor, and I believe that that segues well into a case that I cited in my brief that I think is very on point to discuss in this matter when we're considering whether strong provocation was proven by a preponderance of the evidence, and that's State v. Highsmith, which is from this court, the North Carolina Court of Appeals, said that while an original altercation evidenced a threat or a challenge by the victim to the defendant, ensuing events of a defendant proceeding to his residence, obtaining a shotgun and shells, returning to the vicinity, manifest actions more consistent with a prior determination to seek out a confrontation rather than acting in a state of passion without a time to cool. That is exactly what the state would posit happened here. This defendant went to this home. He doesn't allege that there had been any altercation with the victim that day or even the day before. He vaguely references an argument from 2 days prior, but he doesn't go into details about that argument other than to say, generally, we argue because she does drugs and is drinking alcohol while pregnant. Instead, this case is much more consistent with Highsmith. He went there with a prior determination to seek out a confrontation rather than acting in a state of passion. And he did not approach this house in a cool state of blood that night. So the state would submit that this case is very similar to Highsmith, where strong provocation was not found. And that was when the defendant killed the victim within 20 minutes of an altercation that had been incited by the victim.
But he looked in the mirror and he sees empty beer bottles, so he's probably now at that point thinking, the mother of my child's in there drinking or has been drinking alcohol, and that enraged him, and he instantly shot through the window out of rage.
That conflicts somewhat, Your Honor, with the evidence that his testimony that he came to believe no one was in the home because he didn't hear footsteps, he didn't hear voices. Again, all this testimony.
But his testimony was that he looked through the window, and he might not thought they were there, but that was like, oh my gosh, she's at it again. And he got provoked and shot through the window, just shooting the location where this was taking place. Just like if I just shot into the gambling hall, even though I didn't think anybody was there. That's where my son is screwing up all the time, and I'm mad at everybody in there for having this place. And so he's mad. He's mad that there's this location where mother of my child goes there and harms my baby. I'm just saying if that's what provoked him. Why isn't that why he shot through there? Because he saw the beer bottles. If that's based on his testimony.
His allegation in his testimony was that he became agitated, he became upset, and that is why he began to shoot it at and into the home. I believe, to your point, Your Honor, it's the second piece that has to be considered in conjunction with that first piece, that there was a threat or violence close in time or immediate, and it had to have been towards the defendant. And there was no such thing here. There was no threat or coercion towards the defendant on the night that he shot up this home.
It couldn't be toward a third party like his baby.
Our case law does not support a finding of the mitigating circumstance of strong provocation in that instance when the claim is that it was
So
a
if somebody's
third party.
attacking my wife, I don't get the provocation defense because they're not attacking me.
That is correct, Your Honor. We do not have case law to support that, and that is not how the statutory mitigating factor has been interpreted.
Is there case law saying that it wouldn't be available?
The state does not submit that there is case law out there in North Carolina that discusses whether the third party can be the person that's being harmed in order for the defendant to claim that he was strongly provoked.
Okay. Let's say we agree with you that based on kind of this conflicting evidence, there's not enough for us to reverse the trial court or say that the trial court had to establish this. Let's say the trial court had said this mitigating factor existed. Would that be a problem, or would that have been based on this discrepancy in the evidence within the trial court's purview to say this mitigating factor existed for strong provocation?
Yes, Your Honor. I believe it was in the trial court's discretion whether or not to find mitigating factors in this case, including potentially strong provocation. And that is a good segue into discussing the standard of review in this case, which is abuse of discretion. A finding of mitigating factors at the trial court is discretionary. And the statutory 15A 1340.16a says, yes, the court shall consider evidence of mitigating factors, to my friend's point, but it goes on to say that the offender must prove those mitigating factors by a preponderance of the evidence, and the trial court is not required to consider mitigating factors that the defendant did not meet that burden and prove by a preponderance of the evidence. And that must be substantial, uncontradicted evidence that the mitigating factor exists. And our statutory law goes on to say that even if the mitigating factors were proven by the defendant by a preponderance of the evidence, and even if the trial court considers them, it may depart from the presumptive range. There is no mandate in the statute that it must. And so, yet again, this is abuse of discretion. The trial court had it in its discretion to consider whether this mitigating factor existed if it was proved by a preponderance of the evidence, but it did not have to depart from the presumptive range, even if it did decide that.
She's arguing the court never, the statute also says shall consider, and she's saying the court never considered it, and that's a statutory mandate as well.
I believe it's important to.
Are you saying the court did consider it, or are you just saying that?
It was within their discretion to consider it. They had to consider it, the trial court had to consider it if it had been proven by a preponderance of the evidence by the defense. The state would submit that that was not the case here, that the defendant did not prove by a preponderance of the evidence that he had been strongly provoked or that there was an extenuating relationship between himself and the victim. In addition, the case law says it's not necessary to make findings on mitigating factors when the defendant was sentenced in the presumptive range. And the state would posit that just because the trial court judge may have not said anything out loud doesn't mean that he didn't consider that a mitigating factor may or may not apply in this circumstance. It's certainly possible that the trial court judge considered it, thought through it, and ultimately the trial court judge was there in the courtroom weighing the credibility of the witnesses in the testimony, and ultimately decided, no, I don't believe that these mitigating factors existed in this case.
If the trial court could have gone the other way and given this mitigating factor based on the evidence that, in this view, it could have believed after seeing the testimony, seeing the credibility of defendant, making all those determinations, trial court could have gone with where the defendant was on one or both of the mitigating factors. Then why isn't it IAC that defense counsel didn't even bring it up or develop a record more on those mitigating factors?
Yes, Your Honor. So first, to your point, trial counsel for the defendant was not required to specifically state certain mitigating factors that he wanted the trial court to consider. That is not a requirement that the trial counsel for defense specifically say, Judge, I would like for you to consider strong provocation and or an extenuating relationship here. For ineffective assistance of counsel, it's a two-part test, and this comes from Braswell at our Supreme Court, where we adopted the federal standard. It's the defense must show that the trial counsel was deficient, there was a deficient performance, and that prejudiced the defense. You can, in this case and very often, skip over whether there was a deficient performance and go straight to whether there was prejudice. This court has said in Braswell that if there wasn't a reasonable probability that the outcome would have been different, there is no need to determine whether trial court counsel for defendant was deficient. There was no prejudice here, and so I think you can skip straight to that because defense counsel argued extensively at trial during sentencing on behalf of the defendant. And if I may, I'll let you know that the list of things that the trial counsel argued on behalf of defendant. He argued that defendant has a young son to care for now. Defendant was acting out of concern for that son. Defendant acknowledged responsibility early on. He testified truthfully. That the victim asked that the defendant not be sentenced to an active punishment or as long of a punishment so that she could help share custody with that child and financially support him. Defendant had a steady job. Defendant has a good family. Defendant should be entitled to work release, which was also recommended by the trial court judge during sentencing. So again, trial counsel for defendant was not required to specifically state the mitigating factors that he believed should have been considered in this case, but he is certainly required to make a case for sentencing. He did that. And so if you were to move past prejudice.
So,
Yes,
the
sir.
state's position is if defense counsel reasonably believes there's, or should know that there's mitigating factors that may apply, he's not under obligation to ask for a mitigated sentence just as opposed to a variation in the presumptive range sentence?
The defendant's trial counsel is not required to make any specific request in terms of the exact mitigating factors that he believed may or may not apply in this case.
But even with all those statements, there's no showing that he's actually asking for a mitigated sentence or for the court to find mitigated factors, just asking for what I look as leniency within that presumptive range, correct? At no point does he ever ask for a mitigated sentence.
I do not believe that trial counsel specifically said we wish for the trial court to consider a mitigated sentence in this circumstance. I think that gets to the deficient performance prong, and if you get past prejudice and you look at deficient performance, my colleague has argued the North Carolina Court of Appeals case Davidson, and in that case the defendant's attorney stated to the court that the information provided by the defendant was wrong and that it was inconsistent with the state's evidence, that the defendant hid his criminal record from his attorney, that the defendant's attorney told his client, he strongly suggested his client take a plea deal and that his client rejected. And the defense attorney basically told the court that defendant had no defense. In that case, in Davidson, this court said, counsel offered no argument in defendant's favor, made no plea for a finding of mitigating factors, failed to argue for a reduced punishment, failed to suggest any favorable or mitigating aspects of defendant's background, or failed to even advocate leniency. More significant, the representation consisted almost exclusively of commentary entirely negative to the defendant. That is a far cry from what occurred in this case.
Right, but that's just the worst case. I mean, that doesn't mean that not being the worst attorney means you're providing adequate representation. It's a spectrum. Just why would we compare this only to the far end awful side of representation?
I agree that there is a spectrum, Your Honor. I feel that trial counsel here was on the other side of the spectrum compared to Davidson. The attorney here made a fairly substantial showing of positive factors from defendant's background that should be considered in his sentencing. He went on for quite some time about why the defendant should get less punishment, or why the defendant should not be sentenced to incarceration at all, and because he wanted to pay child support for his son. He wanted to share custody for his son. He had a job and a good family.
Was part of the, but the attorney did argue the issues that would have been in the same argument as the provocation, and because he described why he went over there and all that other stuff. But he was sentenced at the top end of the presumptive range. And I guess I'm going to ask you about that. So would that show that there's no prejudice because the judge just wasn't impressed at all with any of that? So if it asked for it to be considered as a mitigating factor, as opposed to just consider it as a reason to give him a lower sentence within the presumptive range, the information was before the judge, and the judge didn't give it any consideration anyway because he decided to sentence at the top of the range. Is that correct? Am I correct in that?
The state does not believe that just because the trial court judge sentenced the defendant at the top of the presumptive range doesn't mean that he did not consider all of these favorable aspects from defendant's background.
So it was before, because the defense lawyer did argue essentially that he went over there because he was upset about all this other stuff. The same things he would have argued if he had said, and I want you to consider them as a mitigating factor. The only difference was he said, I want you to consider them to give him a lesser sentence in the presumptive range, I guess. And since he wasn't even impressed with that, so what difference does it make that the lawyer didn't make that argument to consider it for a mitigating factor? Because the judge wasn't impressed with it anyway.
Correct, Your Honor.
If I'm understanding that right, and I'm going to ask you why I'm not seeing that same way. So there might not be prejudice anyway. I'm assuming that you're saying that the attorney did argue all the factors that would be relevant for provocation or whatever. He just didn't articulate it in a way to say, consider this as a mitigating factor. He's just saying, consider these issues and give him a lesser sentence in the presumptive range.
Yes, Your Honor, and I believe it's important to point out that the trial counsel for defendant was not required to specifically say, trial court, I would like for you to consider X, Y, and Z mitigating factors. That's not a requirement. And the trial counsel did go into detail about the purpose for the defendant's actions, the reasons why the defendant alleges that he shot up the home that night.
But the lowest sentence under defense counsel's arguments at trial for leniency, the lowest minimum sentence he could have had was 51 months at the bottom of the presumptive range. With mitigation, the lowest possible sentence would have been 38 months. So how is a time period of more than a year not problematic when you're not even asking the trial court to consider dropping down into that category if the factors exist? I mean, putting aside whether the factors exist or not.
Sure.
If the factors existed, how is it not problematic that the lowest you're asking for is 51 months when the lowest you could be asking for is 38 months?
The trial court counsel for defendant was not required to specifically say, I would like my client to be sentenced to this amount of months or sentenced with these mitigating factors having been considered. The state would submit that the trial counsel's discussion with the judge during the sentencing portion of the hearing or the trial did that purpose when the trial counsel went into detail about all of these favorable factors of defendant's background.
I guess, counsel, on Judge, and I know you're out of time, but on that issue, would it be a different scenario if we were out of the presumptive range based upon what our case law, because my understanding is if we're in the presumptive, we're within the trial court's discretion. So there's no perception that the defendant has been prejudiced if we're within the presumptive. So does that factor into what you're saying? There's no requirement for the trial counsel to specifically ask for mitigation if we end up in the presumptive?
I believe that would be a different case, the case that you described, Your Honor, where you discuss had this defendant been sentenced in the in the aggravated range, for instance, that would be a different case. There are different requirements, specifically of the trial court judge. The trial court judge would have had to have made written findings, and there would have most likely needed to have been further discussion on the record about why the judge was ultimately deviating from that presumptive range.
But because we're in the presumptive in this scenario, we're within the trial court's discretion.
That is correct, Your Honor, yes. Yeah.
Thank you for your argument. I'll give you 30 seconds to finish up if you want.
Sure, thank you, Your Honor. I appreciate the opportunity to speak here today. If Your Honors have no further questions for me, the state would ask this court to affirm the conviction and the sentencing in this matter because the trial court did not err in failing to consider the mitigating factors of strong provocation and an extenuating relationship. And further, the state would ask this court to affirm the conviction in this case because trial counsel was not ineffective. With that, thank you, Your Honors.
Thank you.
Appreciate it.
Thank you. Just in my limited time, I'd like to say a little bit about the facts and then move to the questions about ineffective assistance and burden. So first, I want to come back to the whole intent to kill issue and just.
You can go 2 minutes over if you want to, so you got 5 minutes. Go for it.
Okay,
We were
thank you.
interrupting you last time.
So I think it's just worth pointing out, I'd like to revise my answer to point out that in prior cases like Mixian and Canty that are cited in our brief, the defendant actually killed the victim, and there were still mitigating factors present. So I really don't mean to suggest that even if he did have intent to kill, that there wouldn't be the potential for mitigating factors. So on the uncontroverted evidence piece, I understand the state to not be contesting at all the underlying facts that the girlfriend was rampantly abusing drugs, that all of this conduct occurred, that she was completely callous and basically said, well, I can do this, that, you know, it's no problem, I did it with my other kids and it's fine, that this underlying conduct is completely undisputed. And even if this court says, well, when you get into the minute details of what happened at the trailer that night, we don't know if the time lapse is enough to take this out of strong provocation. That's where you have the relationship being extenuating. And you have cases like Canty where there were 48 hours that passed between when the victim provoked the defendant and the defendant went and found the victim and shot the victim. And there wasn't strong provocation in that case, but there was an extenuating relationship.
Let me ask you a prejudice question. And tell me if I'm wrong here. It seemed like that the defense counsel did argue to the judge during the sentencing, please consider the fact that he went over there and was upset about all this other stuff and argued these things. He just failed to argue, and these are mitigating factors, which he should have done. If he should have done that, that would have gotten him to 38 months. But he said at least consider it to lower it in the presumptive range, which would have given him 51 months. But the judge wasn't even impressed with that, gave him the highest. So the judge didn't consider all that information that would be relevant to the mitigating factors. He just argued it for the presumptive range, but the judge wasn't impressed at all that that was even sufficient in his mind to even reduce it to the lower end of the presumptive range. So how is your client prejudiced by the fact that the attorney didn't argue these same facts that he argued anyway should get him 38 months? Because the judge wasn't even moved at all. I mean, I could see that if the judge had gone down to 51 months or somewhere close to there, well, maybe he was prejudiced because he didn't talk about the fact that you could go down to 38 months. But it didn't seem like the judge was moved at all.
Right, Your Honor. Well, I guess
That's
I
a
would.
prejudice question, I guess.
Yes, I completely understand your question. So I think that I would start, there's a two-part answer to this question. The first is that I would really push back on the fact that, defense counsel did not talk about the victim or her behavior at all during the sentencing proceeding. These are quotes from pages 430 to 433 of the
That's fair.
sentencing transcript. He said he testified as to what his motives were. He acknowledged responsibility. He went to the home to save the child, to not do the child damage. His motives in going to the house were good motives, but executed poorly. And he even said something to the effect that, well, this was a relationship that went sour. There was no argument whatsoever about the culpability of the victim, that this was extenuating or that she provoked this offense. And I do think that is a distinction that matters. And then, you know,
On
the
that
other,
on that distinction, though,
Yes.
what's your response to the state's contention that the application of our case law is directly towards the defendant versus kind of your quasi-argument of defense of a third party? In this instance, none of the conduct that he is saying provoking him is directly towards him. How do you address that issue?
so I don't read the case law to prohibit, I mean, that is a common law doctrine that is recognized in our case law, defense of a third party.
Yes.
And while we're not arguing that that applies here, I think there is an analogy, and I don't read anything in the cases to say that that's irrelevant to strong provocation or extenuating relationships. It just so happens that the facts of those prior cases happen to involve a direct physical confrontation. But when you look at what strong provocation is, this court has said not acting in a state of cool blood, that whether the victim physically challenged or threatened the defendant is relevant. And I would argue that that does include a third an unborn, not just a third party, the couple's unborn child. I mean, that has to be relevant. And I don't read any of our cases to prohibit that consideration. But the second part, coming back to your question about the sentencing proceeding and prejudice, is not only do we have, there's really no argument connecting the facts of this case to the fact that, hey, these mitigating factors exist, there's nothing said by the trial court to justify this sentence whatsoever, or any indication that the trial court considered those mitigating factors. And I do think that it's important that when you're dealing with a statutory mandate, like shall consider these mitigating factors, there does need to be enough of a record to show that the trial court fulfilled this statutory mandate sufficient to enable meaningful appellate review of what the trial court ruled. And in Freeman, that was the
Counsel,
case.
where is there a mandate that the court in the criminal statutory scheme has to make findings when it's in the presumptive range? Point me to that.
Right, so there is a difference between making written findings,
Let me
making
ask you,
formal.
does that statutory requirement exist? If it's sentenced within the presumptive to have to make those findings?
So the trial court is not required to make written findings. The trial court is required to consider. And I think that that doesn't take much. It maybe takes a few sentences for the trial court to say.
Couldn't it be listening to the trial counsel listing out mitigating factors on the record?
I'm sorry, can you repeat that?
Couldn't it be considered that the trial court did listen to Chief Judge Dillon's, saying that, hey, some of these things are close to provocation, maybe not, but couldn't it be found that the trial court sat there and listened to defense counsel go through this list of mitigating factors that were close to what he's saying that you're getting at provocation? Is it that really what happened?
Well, I mean, I would dispute that that is what happened, because I don't think that trial counsel urged these mitigating factors in this particular case. I mean, the trial counsel did say something about acknowledging responsibility. In an ideal case, I think because a trial court has to fulfill this statutory mandate with enough of a ruling that the court can review that, I do think that while there are no magic words required, I do think that there has to be enough of a record, ideally with a statement of the sentencing judge, like in Friedman. I have considered the mitigating factors, and I don't find them persuasive as weighed against the defendant's guilt.
So your contention is that right now our case law requirement is that if there's a sentence within the presumptive, that in essence really is the record showing that the mitigating factors were considered or were not, because ultimately we didn't end up in aggravated. So you're saying we should have more than what is required right now?
I'm sorry, we should have more. I think what I'm saying is just that there has to be enough, and it is obviously dependent on the facts of the case. If it's obvious from the context that the court did consider, then that's enough. And I'm not saying it has to be much. I'm not saying it has to be formal findings. But I think it's like any ruling by the trial court. There has to be something that shows that the court considered these factors and fulfilled the statutory mandate. And when you have a record here that's just so lacking in any kind of argument based on the facts of, hey, he was provoked, this was extenuating, I think that is missing. And I also think, going to Judge Murphy's point, that even if the court were to conclude that some of the evidence was conflicting, which again, I think it's not, based on what the state said during its argument about the underlying facts of this situation being completely uncontested, it's still, I think, IAC, I hate making IAC arguments, I think everyone does. I think it is better to just apply the statute as it is written, but it is certainly a backup argument that if this mitigating factor, which is the entire basis for the defense strategy in this case, is to accept responsibility, even if there is no requirement, generally speaking, for defense counsel to urge particular mitigating factors, the question in an ineffective assistance claim is whether it's a sound tactical choice. And it seems like it is not a sound tactical choice to bring this strategy throughout the whole case and then drop it at sentencing and say, well, I think it's too presumptuous to propose a sentence or ask for specific consideration of mitigating factors. That does seem to be objectively unreasonable. So,
I've got
I think Judge
one
Rogers
more
wants-
question for you,
Yes.
real quick. Judge Dillon was poking at the top of the presumptive range being the given sentence and how that impacts prejudice. And the base of his arguments when he was asking for all these things. But looking at sentencing as a whole, he was looking at a total of 180 days potentially active on the misdemeanor convictions, and those were all consolidated into one 45-day sentence. So what impact does it have on this prejudice framework, if any, that he wasn't actually maxed out as a whole in sentencing?
well, he may not have been maxed out to the complete limit, but he was certainly close. The 45-day sentence that the trial court did impose was run consecutively to the very top presumptive range that the trial court imposed. So I think when we're looking at ineffective assistance or prejudice or whether this would make a difference, it seems quite clear that the trial court did go along almost entirely with what the state suggested, and there is a lot of room for the trial court to say, well, maybe I would go downwards in the presumptive range. I mean, you were reading off the ranges. This is a range of potentially years that could impact the sentence. And so I do think that there is prejudice when there is the possibility that had the trial court really meaningfully considered this evidence, that it could have imposed a far lower sentence.
Thank you.
So thank you. We would ask that the
30
court
seconds.
vacate and remand for resentencing.
Thank you all for your arguments. Thank you for your patience with the court. And we appreciate it. We'll take it under advisement.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
You too. Thank you so much. Sorry, my answer's funny. It was nice to meet you. Nice meeting you too.